אוקיי, אז תודה לכל מי שהגיע היום. יש לנו פה קהל מאוד מגוון של שופטים, עורכי דין, עורכי דין, אנשי אקדמיה, שכולם ככה מאוד מחויבים לעולם הגישור. ואני אעבור לאנגלית לטובת הלקוח שלנו. The goal of this class, of this master class, in honor of Judge Weinstein, who is visiting us from the United States, is to share the knowledge of successful mediation. I will make a short introduction of Judge Weinstein and of Amos Gabrieli, who some of you know. Judge Weinstein is one of the US nation's prominent mediators of complex multi-party high-stake cases, both in the United States and worldwide. He is a pioneer in the development of mediation and the founder of GEMS, the world's largest provider of alternative dispute resolution services. Judge Weinstein designs the process and oversees the resolution of challenging securities, class action, mass torts, intellectual property, antitrust, entertainment law, and much more. Judge Weinstein served as the US Special Representative to Bosnia for privatization of overseas 14 billion transfer of funds to Muslim, Croats, and Serbs during 1999 and 2000. Judge Weinstein's other international work includes mediating the Swiss Converium case, the Parliament case, and the Shineal Bank finances disaster in Tokyo, and much, much more. Judge Weinstein is the founder of the Weinstein GEMS International Fellowship Program, which includes about 80 fellows from 60 countries. The fellowship provides opportunities for qualified individuals from outside the United States to study dispute resolution processes and practices in the US and to assist them in their efforts to advance the resolution of disputes in their home countries. I had the honor to be the first Israeli Weinstein Fellow in 2010, and I can tell you that this is a life-changing experience, being able to learn from experts in the US and to be connected to ADR professionals all over the world really advanced my mediation skill and my ability to go back to my country and develop ADR in different levels, the public, the academic, and also the private. Amos Gabrieli is also a Weinstein Fellow. Some of you know him as a mediator, participated in cases which he mediated, and he's the founder of the firm A. Gabrieli Advocates, Mediators, and Arbitrators. We are located in Kfar Saba. He is known for the development of a new doctrine involving active along with evaluative mediation, based on a vast knowledge and proficiency in various areas of both national and international law, in addition to more conservative methods of mediation. Advocate Gabrieli has been conducting mediations in multi-complex corporate and commercial cases in the USA and Europe for the past few years. So we will try to demonstrate successful mediation, which happens every day in Israel, in the US, and all over the world, and to share some of the knowledge, the valuable knowledge of Judge Weinstein and Advocate Gabrieli with the audience. So I'm going to ask some general questions, and then we will open it for the audience to participate and ask. So let's start with you, Amos. How do other roles you had within the system? You used to be a litigator. relate to your current role as mediator.
Should I stand up and speak from there, or can you hear me from here, or whatever?
No, comfortable.
Right. Firstly, thank you for coming. It's a great honor to have Danny, Judge Weinstein here. As I call him, the Bruce Lee of all the mediators. So he's the great master. I had the privilege of being in the United States, meeting Judge Weinstein for the first time, hearing the myth, meeting him personally, falling in love, and since then it's history. So the interesting thing, and I will relate it to the question, Hagit's question, is the fact that I've never met Judge Weinstein before, I never met him before, but when I came and I've seen him the first time in New York, I realized that both of us work in similar manners in a way. And when I try to analyze what the features are, I will use terms that could be some kind of abomination with regard to mediation, because we are going to mention the word authority in mediation, which I heard before, and I couldn't believe that I heard it, because looking at the classical ADR, mentioning words like authority in the ADR seems to be so much of a confusion, so much of contradiction in terms. So in that sense, I'll elaborate later, but I have started as a litigator, and I must say that my teacher and my partner was an advocate here in Israel, Danny. His name was Arnold Speer. Now, he did everything but compromise. Compromise was a bad name for a lawyer. Compromise was a bad name for a human being. When I even suggested him once when I appeared in a court in Jerusalem, it was 400 years ago, and I even suggested that there might be a chance of a compromise. Speer asked me how exactly I would like to be sacked from my office, through the window, through the door, and what happened. That was the method I was raised in. Zussman, which is the civil procedure, was my Bible for quite a few years. So I actually grew up in a formalist, the most formalist manner of all. We had no remorse for anyone who offered anything but a judicial decision. And I was raised like that for quite a few years, went to court, litigated to the bitter end, regardless of the benefit of the parties, the benefit of the lawyers, or the benefit of society. Couldn't care less about anything like that. So that was the background. The background was formalistic background. I was working in the Ministry of Law in the first couple of years. I used to be the assistant to the legal advisor. So when you deal with international law, you do have more time or for compromise, for negotiation, for taking legal terms and putting them into practicality. So I did have at the background this international law experience that brought me eventually to the position where I was here. So working for the Ministry of Foreign Affairs, working for Mr. Procedure himself, the late Mr. Procedure, yes, and brought me to this. And the last thing that I think that attributed to the fact that we could actually make agreement is that I held public position. I was the deputy vice mayor of the city. So while you're holding a public office, then you tend to solve problems, cultural problems, problems with regard to neighborhoods, to schools, to other politicians, all this together bring you different aspects of conflict resolution. And I think that if you combine all of this together with luck, with destiny, with something which is random, could bring you to a situation where you ask yourself, how the hell I'm finding myself now in the position that I'm finding myself? So there's no real answer. It's altogether probably even more. So this is what I can see attribute maybe to the fact that at the moment I'm doing mediation. But it's something interesting. You know, you always said retired judge. I was thinking before, is there a retired mediator? There's no such thing. So we cannot retire. The concept is that you are mediated to the bitter end. And the funny thing is that yesterday we had a mediation together for 10 hours. We conducted the mediation in the office, and it was lovely. 5 lawyers, beautiful English, everything was excellent. And then one lawyer said, when I tried to convince them, as we do sometimes, that his claim is not sufficient enough to hold in court, he told me the following, and Judge Weinstein was, I think, fascinated. He said, Amos, I love you. If I need to die, I'd rather do it in court. So when we speak about mediation, you always have to remember that the way I see it, which probably is the wrong way, but I insist to tell you that now because I was invited. So you could die in mediation as well, in that sense. So that's it.
Please, Judge Weinstein.
How I came to mediation. I hadn't really even thought about it till Amos started talking, and I did get the treat of shadowing him yesterday, and I'm usually being shadowed, so it was really a treat for me to sit and watch someone of his skill performing the art that I've given the last 30 years of my life to, but to watch someone performing it with the mastery and skill that he did was really a treat, and I've rarely seen that around the world. But I got to this, I guess I grew up in Chicago. My father was a rabbi, and we sort of lived with the idea that all the Jewish jokes about the divorce case where the husband complains that the wife is horrible, and the wife complains the husband doesn't earn, and he plays pinochle all day, and he spits on the floor and everything else, and the rabbi says, you're right to both of them, and then the aunt Tevye comes up and says, Rabbi, how can you say to the husband he's right and not 5 minutes later tell the wife she's right? Well, how can you be such a hypocrite? And he says, you're right too. and we grew up sort of with that. You're right too. And I think then I went to law school, and I went to undergrad law school, and then I was the public defender for a while. Then I ran the DA's office in San Francisco for 3 years, the district attorney's office, and then I went on the bench rather young. I was 35 or 36 when I went on the bench, and I loved it. I ran the juvenile court a long time. I enjoyed that, and then I went on the civil bench, and I began to sit through these long trials with lawyers being paid obscene amounts of money to stand up with depositions, boring jurors to death and repeating themselves, and I was trying to stay awake, and all these asbestos cases backed up for miles of stuff, and I said there had to be a better way. So I decided to leave and to go out and to start this crazy idea of jams with another judge who left at the same time. When I decided to leave, the newspapers came up to my chambers because no one ever left the bench except either dead or when they because of the good pension and such good life. And he said, "What's the scandal? What's the scandal?" And I said, "No, I'm not leaving." He said, "Well, then you must be leaving for the money." And I said, "Well, I don't know." I said, "I'm just bored doing what I'm doing, and after all, money isn't everything." That was really a dumb thing to say, because my law clerk was sitting there, and he looked up and he said, "Yes, but it ranks up there with oxygen." And the next day in the paper, that was the story, that money ranked up there with oxygen. So I went out, we started this, what later became, as Hagit said, the largest provider of service, mediation services in the world. And by the way, we're a cooperative. We were once, there were 2 or 3 of us who owned it, and we turned it into a cooperative. And so JAMS has never been a law firm model. It's owned by 100 owners, or 150 of the members of it own a little piece. We all own a piece of it, and we're cooperative, and we would just sort of share the facilities and the services of JAMS, but no one makes money off of someone else. Everybody sort of does whatever they do, and I think it's been a much better system than the traditional law firm system where the senior people are making up the junior people and so on. I pass that along for those of you who are entering that business here. But when we started out, just so you know, because I couldn't understand all of what you all were talking about, but all of the difficulties we had culturally to get it, to get mediation and ADR accepted existed, maybe not as fiercely. I mean, I don't know that anything was as tough as breaking into the Israeli system of arguing and litigation and being right, but we had a tough time at the beginning, and we had everything going for us. Our courts were overcrowded. There was the cost of litigation was just enormous. Strangely enough, the unknown secret is it was the insurance industry that really helped us. When interest rates were very high back in the 80s, 70s, 80s, and 10%, 8% interest rates, the insurance companies don't care how long litigation goes on. In fact, they want to keep the money and keep litigation going for 5 years and pay later because they're making these huge returns on their money. When interest rates went down to 5%, 4%, suddenly lawyers were costing them more, and keeping the case going was costing them more than they were making. And they became the great friends of getting cases settled. It's interesting, most people realize, but they became our allies in saying to lawyers and changing the culture and saying, get in there and start mediating your cases. And they and corporate counsel, because of the huge cost to corporations of corporate fees and so on. I say that only because you find strange allies in getting the ADR system going. So we fought the culture, and we slowly but surely it became a phenomenon, and where most cases in the United States are mediated, and so I became a great believer in it. We've watched this movement over 30 years. And one thing I just want to say, to start off the discussion, and I hope we can answer your questions rather than sort of answering ours and telling you in the short time that I have with you, because I'd love to be able to answer any questions you have, because two things. We really saw this movement start from nothing and to where at least it's ingrained in our system, and we have changed the culture. We haven't changed the way lawyers talk. We haven't made most of the bar into real mediation advocates. That's something we can discuss later. I know one of your speakers was speaking about mediation advocacy, but most of the mediators, and I will say that maybe 10% of the lawyers that appear before us know how to operate in a mediation and how to use language properly and how to treat the other side and how to use their client in a mediation and how to properly relate to the mediator and how to prepare mediation and so on. So we got a long way to go still, but we've made every mistake in mediation. We've seen all the models, all the high priests of you got to be facilitative, you got to be evaluative, you got to get to yes, maybe, get to maybe, get to yes, get to no, all this stuff drives you crazy, okay? We've seen it all, and we've seen who's successful in the private sector. We've learned a lot about training and how what works in training, what doesn't. I think we've got a pretty good idea on the profile of people who can be successful as mediators. And so we've just had through trial and error to learn a lot about it. And I finally, after 30 years, sort of have a sense of what I think is the most helpful model, and we'll talk about that when we get questioned, if there is a model at all of how it's done. It's been helpful to me, but it's taken me a long time to kind of get there, to sort of understand what we do. I think I did it unconsciously for a long time, by rote, and then eventually, as in most things that people do, finally you understand it at a different level. So at some point, I'd be happy to share that with you, at least for what it's meant in my career.
So, any questions to Judge Weinstein? Anything that... Okay.
What's that? You want?
Yeah.
Well, okay. How did you ask? All right. And then I want my buddy Amos to jump in and tell me, because I watched him operate yesterday, and to operate what you might call the authoritative or evaluative model, as well as I've ever seen anybody do it. I'm not just blowing smoke at him. I just haven't seen anybody operate that. And there are, of course, critics of that type of mediation who would say, oh, no, you don't, you facilitate and you move people and you don't sort of direct it in the way that he is, and so on. But I'm not sure. Those are the terms that I applied, and if you'll indulge me for a moment, it came to me when I read a quote, maybe about 4 or 5 years ago, from Rumi, the Persian poet who many of you know, and he said in one of his letters, beyond the arena of right and wrong, there is a field. I will meet you there. And somehow that just stuck with me, that there was an arena of right and wrong where people come to us believing that they're right and the other side is wrong, and that our job was to learn to operate in the arena well enough to guide them somehow into the field. And when they got into the field, that's where it was very humbling to me to find, I think that once you got there, all sorts of things could happen. And maybe that sounds sort of California woo-woo, that's all. But it really isn't. It's just that it gives, what we do, in opinion, is people start in the arena out here. And we give them their day in court. And the same way that you let them have the chance to be heard. And you as a mediator learn to listen in a way that doesn't come naturally to everybody. To learn to really listen and to give someone the feeling that they're being heard. And you watch almost what happens when people have a chance to. So that's why I encourage often the lawyers to let their clients talk and just to be heard. And then, they're here in the arena, and then you, if you're a skilled mirrorer, which is one of the things I think we do and that I watched Amos do almost naturally, which was to take what people say and to feed it back to them, but taking some of the thorns out. Taking the demonization, the victimization. So if I heard you correctly, Ms. Jones, you said you know, that you really, this was a horrible accident, you've been in terrible pain, been so-and-so, but, you know, you also said you're feeling a little better now. That's encouraging, and you're thinking about going to work, back to work next month, and so-and-so and so-and-so. But it doesn't matter, you take what people say to you and you try to give it back to them, or to give it back to the room, I do, in a way that is, that takes out a lot of the invective. And then you do the same thing with the other side. And they hear it, and they get a chance to tell you everything that they want to tell you, and you kind of feed it back. And as you're doing that, of course, you're moving people in some way from here to here. That may happen not instantly in the exchange of the stories and the ideas. It may happen as you begin the negotiations. But I always see that our job is to keep people in the game, not let it blow up. And people, I spend a lot of mornings at 11 o'clock, I'm at the elevator saying, please stay, please stay. I came all the way from Eilat to hear that. I'm out of here, you know, I'm gone, you know. And just say, sit down, please stay, you know, don't. And so people sort of keep them in the tent and keep it going until you can get them closer. And once you get people closer, the secret to our success, in my opinion, is that people do different things when they're closer than when they're far away. They do different things when people aren't demonized, when they're not victimized. So it's such a simple fact of life. And it's true in cultural negotiations, it's true in the smallest case, it's true in a divorce case. So when you begin to narrow the conflict and so on, because everybody comes in, I've been doing this 30 years, 2,000 cases, I haven't had the case yet where people come in and want the same thing. I'd screw that case up, I promise you. I wouldn't be able to do it. You know, they teach it in all those mediation courses you take. You just say, well, where are you, and where are you, and where are you, and suddenly they're together, and we sing Kumbaya, and that's the way it is, you know. But I haven't had that case yet, okay? So you have people who want different things, but you kind of take them to where they see the end. They can begin to see each other. They see that there's a solution. And then there's a lot of different ways that we in the profession sort of break logjam or do it. Someone very directive like Amos leads people very strongly to that conclusion. But he too's given them the chance to move closer and so on, as I watched him do it. Other people do it through mediators' proposals, or just some old-fashioned negotiation, or using brackets, or doing, but in my original analogy of Rumi, and whatever it is, when you get them here, what I think what has evolved in the mediation is, at that point I try to move them into the field. And I know that sounds a little corny and so on, but in the field, there's room for a whole bunch of things to happen, like grace. Once in a while, actually you see some grace, some decency, some humanitarian. I mean, funny things happen when people get out of the arena and out of the victimization, demonization, the name, and into a place where they see the end, where they have someone sort of reshaping the language of the conflict and so on. And then there's room for a lot of things that happen. And I think as you get more sophisticated in this, and even if you have a great appreciation for the legal side of it, and the rule part of it, and part of watching Amos is his mastery of the conflict itself and the underlying facts and the law and so on. You can't just do this because you're a fine fellow and you're a good humanitarian and you know how to pick thorns out of things. Because underlyingly, you have to have a legal or a factual framework that people respect. It was an interesting mixture of what happens. But when you get into the field, it's not all law and logic. There's room for dimensions and for things to happen that stun me when they do. And I deal with the most miserable, toughest, financial, from Enron to Adelphia to all of the billionaires and the masters of the universe and all these people who think their power comes straight from Yahweh, and so on. But when they get into the field, even they sometimes surprise you. And it's where company culture comes into play, where I've said to people, in Hewlett-Packard case I had listening, I said to some guy, would David Packard be proud of you today if he was here? I kind of looked at him like, kind of stunned of what, but it was a different kind of an approach and a different kind of thing. So long-winded way of sort of saying what's a model. I don't have a model of a style, because we'll talk about that later, because there's all kinds of people. Not everybody can be Amos Gabrieli. You just ain't gonna, with that dynamism and personality and all that stuff, you're not gonna find them everywhere. But they're very successful mediators who do it differently. Quiet people, not like Amos. There's some quiet people who are very good mediators, believe it or not. And so but it's helpful, I think, and the most encouragement I can give you if you're mediating as a judge or as a private mediator in anything is the rules of let people be heard, learn to listen, learn how to give it back to them in a way that's not as toxic. Move them, keep them in the game, move them whatever way you can so that they can see the goal line, somewhere they can see the end. And then there's a lot of different techniques which we can talk about in what I call the field. You may call it something else. It doesn't matter what name you give it. But it's a very exciting, when it works, it's wonderful. And there are a lot of ways to get there. And so I hope that's helpful to you just as a model, but it's certainly served me well.
Amos, can you please explore a little bit about the relationship between authority and consent? How do you play it in your practice?
Well, I'm speechless. I think that while Judge Weinstein is here, it will be worthwhile for us all to listen, because it's an encyclopedia of knowledge and the master of human factor. And the fact is that I totally agree that there's so many ways, quiet ways, other ways. The individual is important. The charisma is very important. The charisma is a matter of personality. The spice, your background, vast knowledge of the law that we're talking about it here. I'm not sure that 10 years ago, when we're preachers of mediation, we're talking about mediation, I'm not sure the vast knowledge of the law was a factor. Because many mediators started mediation asking not to submit the statement of claim and statement of defense because it's irrelevant. The relevance is what the parties are going to tell you when they're actually approaching you and sitting in the room. But when I started demanding people, quite a few years ago, I asked them, I would like to see what you've written on your statement of claim and defense, and so asked me why. What's the point? The point is that you came from court, and you're coming now, and there's no way you're going to forget the court, and if something will happen now, you will go back to court. So let's at least examine it. Let's see the reasoning, let's see the law that you're depending on, because people who sit in the negotiating room are looking at you, and they see the judge. They speak about mediation, and they're doing litigation. And in that sense, if you do not take that into account, and this is the consent and authority, then I think that you're missing an interest. So let's not speak about right, let's speak about interest. You're missing a vital interest of the parties who actually comes there to find out that there is a way of getting out. Now, I don't think mediation is an alternative. I think the ADR, alternative dispute resolution, it's a mistake. It's not an alternative. It's a different way. It's a different way. I'm not sure what the alternative now. You know, the vanishing trials and all this new.
They call it now amicable dispute resolution.
I didn't even know that. But for years, I thought that even the name alternative diminishes the process, takes out the juridic approach or the legal approach for it, or putting it aside. And it definitely looks inferior as well, because if it's alternative, then it happens when other things doesn't happen. And if that doesn't happen, then you go to the alternative, so it must be inferior. And if it's inferior, then lawyers don't need to know how to behave there. Parties look at it as a temporary, momentary event that might be successful, might not be successful, but eventually will go back to court. Now, we changed that. For the past 15 years, we established a practice that had changed that. And that's the consent, because there will be criticism saying, so what is the difference? What is the massive difference? Because eventually when you come to mediation, even when I'm very loud in the room, or I'm not very loud, but I'm conducting it with authority, it's a kind of, you know, I'm coming from music, which is my main area. So it's a conductor.
It's pretty loud.
Yes, it's pretty loud. But Danny, you can conduct like that. You know, you've seen, you know, Riccardo Motti. That's the way it does it. It's very simple. But you don't disturb them. You do not disturb the natural process coming in the room. Now, there are many lawyers that I see here that I've seen so many times in mediations. Okay, so if I say something which I don't see because I'm conducting the process, please tell me that, because it's very important. When Judge was talking about his vision of what he saw yesterday, I look at it and sometimes I don't even recognize the process because that's the way he looked at it and I was sitting performing. I say, it's very different to look at yourself and you do it, even if you do it thousands of times. So the consent element is there. They are coming to the room because they are there to reach things. I don't know what autonomy is. We have so much about autonomy, about contractual autonomy, about free will. I'm not even getting into free will now, because if you look at any contract and you're asking if this contract was achieved by free will, it's a big question. But the way that they perceive their position in the mediation room, in the mediator's room, is different to the way they see themselves in court, and that's enough. So if they come into a different venue, they expect to see maybe something else. So in that sense, the consent is there initially. Now, eventually, whether or not I'm dedicated to the agreement, they sign the agreement. I do not sign, against all rumors, I do not sign the agreement that is submitted back to court instead of the parties. The parties themselves sign willingly. There is a Supreme Court decision that was published a couple of days ago about a case that I conducted. And I conducted the case. It's public knowledge now because it was published and it's everywhere. I performed this good mediation. It was a long process. 10, 11 hours, finished, signed, done. I've sent it to the Supreme Court, and a couple of days later, one of the parties decided that he changes his mind. Changes his mind. He doesn't want to be. So he could not approach court with his lawyer because the two lawyers were there. They were assisting him. They explained together with me the consequence of the signature. And so the Supreme Court got his own request, handwriting, and made a decision with regard to whether or not a party who participated in a procedure based on consent is entitled to regret and to revoke his consent 2 days following his signature. The judge decided against it, Baron, for many reasons. And she said that there is always a way to approach the district court on the ground of misrepresentation by the other party, or because the mediator put a spell on him. This is another myth. You do not use magic. Not any magic as a whole, not black magic in particular. You do not. People, rich, and so many people, my friend here who stayed with me in so many long mediations, eventually, as Danny said, Judge Weinstein, you bring them closer, you take away a lot of bits and pieces of the conflict, and they find a way to agree. That's the consent. Now, the authority is not in the agreement. The authority is the process. The authority is the nomination, is by the nomination. The authority is by the goodwill and the reputation. The authority is by the expectation of reaching an agreement. The authority is in the commitment of coming to a mediator not to waste anyone's time, not to gain information. Not to gain information. You go there because you actually minded into an agreement. So this is the authority. The consent is the agreement. And it's all clear on the table. This is not a hidden persuasion. This is not any hidden way of putting parties into a place they don't want to be. It's all on the table, including the rules, including the touch of authority in the process, which is very important, because there is something about mediators manipulating parties. It is not manipulation. We put everything on the table. We are exposing the authority, asking the parties to participate, and if they give the consent, then it's a legitimate tool in the mediation. So it's a public authority in the private room of the mediator. It's totally different to manipulation or hidden ways of a clever mediator bringing a party to a place which otherwise they will never agree with, otherwise will never reach. So that's the tension that I see.
Judge Weinstein, according to your experience and maybe other fellows in other countries, do you think that regulating ADR will promote the field, or should it be just a free market? You know, let the forces do whatever is best for everybody.
I think the free market's done a pretty good job. I think there are judges here who may say that to let so much of the law be made without voluntarily by mediators, often who aren't, may not be judges and others, and to make all of these decisions without any standards or rules is subject to some mischief or abuse. We don't have any standards for becoming a mediator. We are just have some evolving case law about what the limits of confidentiality and other rules are, what kinds of agreements. Are there any ethical provisions of a mediator permitting a discriminatory agreement or one which takes advantage of another party? Do you have some ethical responsibility? There are no guidelines to that. And pretty much the law has said that it's a protected process. The parties come to an agreement. It's enforced by the courts. And we have a system whereby it's immediately enforced through an expedited system. So if you have a written agreement, it can be automatically enforced. So I'm worried about it being overregulated. Sound like Trump, I guess. But I'm worried about it being overregulated. But I really do, as a former judge and as someone who's seen from time to time abuses of the system that it needs some outer parameters. But I don't want to see it highly regulated. I think that'd be a big mistake.
And we only have a few more minutes, so anyone? Mickey? That's Mickey, not it.
I'd like to ask a question later.
Okay.
So he spoke about the field, and I was wondering to what extent, and it's really interesting that you spoke about bringing the parties to this field and listening, and Amos spoke about the authority and the extra input that the mediator gives into the negotiation that gives the parties the incentive to settle. Do you think that this kind of mediation that we speak about is both, or that ideally, I mean, usually in mediation, when it develops, the mediators become less involved, maybe the parties are more in the field, and the transformative model is the mediator is not even controlling the process. So what do you think about the role of the mediator as involved in terms of the idea of the parties getting into their shared area?
Oh, well, I actually think we'd agree more than disagree. I have cases where my role is merely to be a good courier and to keep it going, and the parties have the ability to sort of come to an agreement through some just help in the negotiations and so on, and I have almost no evaluative role, and I'm not, other than pushing them about the money, I don't have any evaluative role. And then I have cases in which they came to you because they wanted your input and they really wanted guidance. And knowing when to stay out of the kitchen and when to get into the kitchen. And when I used to run jams and I was the chairman, I got far more complaints about mediators who weren't aggressive enough than I did about someone coming in and saying, oh, we had a retired judge in there and he still thinks he's a judge and he was ordering us around, or he was pronounced. The biggest mistake you can make is to go in at the beginning of the day and say, I know the answer to this, folks, you know, and pronounce it. So you have to sort of move people along, and most of the time make them believe that the solution came from them. And that's a mastery of its own, as opposed to this is the way it is. You really try to bring it from them and give them the power of making the solution. But I just think it varies widely by the dispute how much your input is. There are times when I think you have to be extremely authoritative and strong, or there will not be an agreement, and that's what the parties wanted. They really wanted that kind of strength. And you'll see that the most popular mediators in our committee and so on are not shy, and they're not, but they know when to back off. You know, I had breakfast the other day with one of the top mediators in the country, and we were talking about exactly that subject. When is it time to back off? To let the parties go home and think about it, to let it percolate, to not push people into we weren't put on earth to push people where they don't want to go. And yet we want to be forceful and get to an agreement, but you can get a mania about getting to an agreement that can sometimes not be the best thing for people. So it's an art form of when it is to push, and when there's a time to kind of back off and let people respect the dignity of people to stand on a principle, or to go home and talk to their family about it, or to let it sit for a bit, or to tell them, go try your lawsuit. You need a call. You people, I think, need a call. There are cases where you know, that really belong in the courtroom, in my opinion. Not everything is susceptible to kind of middle mush and a deal. So that's just judgment over a period of time.
I totally agree in a sense, but I'd like to ask the question differently.
He agrees in a sense.
Okay, so I'll rephrase. I agree in a bad sense, but I just...
You need a mediator.
Let's rephrase the question. Will I let myself be surprised by the outcome of the mediation? That's the same question. And I actually asked myself this question. Is part of the control you're assuming is the fact that you go into a linear way that brings logically, but at the same time you're looking at other elements, to a probable position and maybe a settlement. Will I let myself be surprised? The answer is yes. It's part of the maturity of being a mediator. I suppose that at the beginning, because you heard Judge Al-Sheikh before when she was talking, she said sometimes I came to court and I knew the answer, the result before they even started. It's very tempting. It's very tempting, but it's a big mistake. It's a big mistake. So I'm willing to let myself be surprised by the outcome, which means I let the parties take it to the place that they're willing to take it, sometimes regardless of my view of the legal possibility. Now, legal problem. The legality of the process is important only because people are expecting you to tell them whether or not they got a better choice. You will not sell somebody something which is worse than the worst case scenario in court. It will not happen. It will not happen that you can be the most convincing person, but eventually if what you tell them to end up is something which is worse than the worst case scenario, the worst position in court that they can see as the worst case scenario, they will not do it. So it's really a very delicate process. And every mediation is a different universe, is a different story. The same party are different in different countries. The same lawyers are different when they have different clients, and you are different as well. So every morning when I start my mediation, I know nothing. As Manuel said in 40 Towers once. I know nothing. I start my, Yochanan always knows that. But when we start the mediation, you know nothing, but you know more and more during the process. And if you don't make mistakes, and that's why I'm a bit prudent, a bit cautious about judges who become mediators at the beginning. Judges who become mediators at the beginning, they've got what we call their temperament as judges. And the way that they know that eventually if parties do not settle, that they will make a decision. And the decision will settle the case, maybe not the conflict, but the case. Working now with a friend of mine, good friend of mine, Avi Zamir will join the practice, so we can see together what's happening. The first few mediation, he wanted to scream, this is the court view, and that's the beginning and the others, but it's very difficult. You have to apply reason, you have to apply emotions, you have to be very prudent, and you have to be surprised, or ready to be surprised by the results. So in that sense, I totally agree with just to make it peaceful.
Nikki?
There was a question which I already got an answer to what I was about to ask, but Amos, you were referring earlier to your legal preparation as a means of ascertaining, since the parties will actually litigate, or at least the lawyers to be in a very safe zone, provided that this is what they are going to do. But in terms of what it implies, this is a question, not a remark. Would it imply that the nature of the actual negotiation will be of a certain type that simply derives from the fact that they litigate? I'm asking this because within the Hagit program, for example, one of the earliest assessments that Hagit mediators have to make with the parties and the lawyers is whether they are able to switch between different ways of negotiating, and specifically within the wording you are using, to switch between litigation and something else. Then we can name it in many different ways. So I'm just asking whether when you speak about litigation, you also, or you necessarily speak about them maintaining this style all along the litigation process, and if yes, what would that imply in terms of its results, or the possibility to be surprised by the results?
Mediation is a kind of a dance. Most lawyers who come and appear, they're lawyers. So they can maintain practice before, and you can do all these exercises and simulators. The second they stand there and they've got the client watching them, the lawyer comes out of them. So it's evident that we will have certain kind of litigating aspects in the negotiation. You should be aware of that. You should not condemn that. You should look at it but put it the right proportion. Okay? So yes, the negotiation is sometimes legal, sometimes it's completely not legal. Sometimes it's totally emotional. Sometimes it's surprising. This is not court. There are no rules. Okay? The rules are the rules that you maintain and establish during the same process. Some mediation, but there's something that we must say here, Mickey. For some reason, which we are not aware of, obviously, it's a self-fulfilling prophecy. People who come to me for the past 7 or 8 years already coming with multi-couple cases, the top 10 lawyers in each firm. It's always the head of the firm who comes and sits there to put his authority on the table and count the money, and then you have other people sitting on the left-hand side. So it's the formal way of starting the mediation. The art is maneuvering them all into this other sphere, which implies that feelings are important and there is a long other interests that you put on the table apart from the rights of each party. So the answer is yes, you do have some legal aspect of negotiation, and you don't have. As long as you don't fight it, but you know how to take it to the right direction of a consent, then you're happy. Once you make a mistake because you objected, then, as we say, the process, then we start begging. As Danny said, he goes to the elevator. I'm a known beggar as well, you know. I mean, I ring people and I call people in the middle of the night and every 24. I mean, I never give up. The case is just, the judge is writing the judgment. Just the signatures, and I'm calling. It happened to me. I have cases where a second before the judgment was sent, we send them a mediation agreement. One of the things is to be persistent and to think about different ideas and different options and look at all of them together. It's a complicated issue. It's not magic. It's hard work. We are blue-collar mediators. We work very hard. That's the secret. That's the secret. So that's what it is.
עוד שאלות?
I have one question.
כן.
The judge told us that he knows to see who will be a good mediator. We'd like to know what are the human characteristics that he already sought, and also Amos.
What it takes to be a good mediator?
It helps if you're devilishly handsome. Those are two qualities, and tall. I think they're, pretty standard. The things that you probably would think if you were making a list yourself, of being a good listener and having a good command of the legal world and so on. What I think is underrated is common sense. I mean, most of the mediators I know who are most popular, it isn't that people say, boy, Bill Smith, he sure knows a lot about antitrust. That's why we go to him. It's important that he knows for a big antitrust that he can speak the language and he's conversant. But they go to Bill Smith because he's got good common sense, or Sally Jones, or whatever it is, because she's a solid person. And so I think if I look around at the different styles of mediators and so on, some use sense of humor effectively, other people are very stentorian and strict and so on, and use the common theme that I find for the most successful mediators are they're just solid people with good common sense, and with that comes an exquisite sense of timing. Because really, what we're doing is waiting for the right moment in mediation, and there's so many ways you can screw up. I mean, we're like a bird out on the flat because the insurance company, the CEO of the company, the plaintiff, there's so many people you can offend, there's so many things you can do wrong, and so on. It's when to make your move, when to finally say to people, okay, enough, heard enough, it's time to get serious. When do you make your mediator's proposal or whatever it is? So, long-winded way of saying, good listener, good, obviously intelligent enough to have a command of the subject matter area, but the biggest quality is solid, good common sense, and the ability to apply it to the right sense of timing. That's at least what I would say.
Thank you so much for sharing with us, Judge Weinstein. Amos, Vicky, would you like to... We would like to stay here, I think, all night. It was great. If one thing I learned is that we have so much to learn. This is so intriguing, and I'm in this field, I think, 20 years. And I don't think we know enough, and I don't think we still have a model or a coherent picture of what happens here. Maybe this is the great sign that, first of all, we academics have a lot to do to catch up with what's going on. And I think also the fact that it's so much established, it's so much part of the system, it's so much part of law, means that we've done some kind of mileage with the mediation. So thank you so much.
Can I just add one last word? I'm messianic to you because I love this country and I love what you're doing. The work that we have to do left in our system, and I know you do in yours, is to change some of the legal culture. The lawyers need to learn a new language. They need to, instead of saying your case is nonsense, it's nuisance value, all that, they need to be able to say, I think it has modest value, or whatever. I mean, they need to learn a different language than they learned in the courtroom and how to do it. And whatever training, whatever you can do to get lawyers to see that they can be great litigators, but that being a mediation advocate is a different art form. It's just a different set of skills. And that it isn't being weak or a sissy. I used to have friends that said, mediators are sissies. You know, they're not real men. Real men are trial lawyers, you know, they go to court, you know. But so that's a lot of the work to do, is with the Bar Association, with training, and to get lawyers to look at mediation, not just that they go to Amos and try to out-lawyer the other guy, but that they go there with an object of getting a result and new methodologies of getting there. So I hope you'll do that work within your Bar Association. It's very important.
Thank you, everybody.